Thank you very much. Just before we start, so that you both know, as you would expect, we've read the papers, although speaking for myself, I haven't read the last few authorities which arrived subsequently, but we have read everything else. So you can take it we have what we think anyway is a lively appreciation of the issues. So you can take quite a lot of this stuff as read, but obviously please make your own, take your own course in terms of the submissions that you make. And whilst I'm sure it isn't going to be a problem, but just so you know, we'll need to stop about 4:20 at the latest because we have other commitments after court. I'm sure that won't be a problem, but just so that you bear that in mind.
My lord, I'm grateful for that, and I'm confident it won't be, and I also hope I can get straight to the points, and I'm grateful for your lordship's very helpful indications. I appear with my learned friend Mr. Tew for the appellants, and my learned friend Mr. Mallew, King's Counsel, and his learned junior Mr. Teasdale appear for the respondents. Your lordships know that this is an appeal with the permission of the costs judge from his reserved judgment on the 1st of February, recognising as he did that it raised a point of general importance as to both whether the Court of Appeal authority and Tim Martin applied, and also if it did apply, how it applies in the sense that, in the sense of what it means and what it says when it does apply. And that the how is the general point, the whether is whether there's a distinction between two subsections in the Solicitors Act. So, my lord, if I may, I'll go straight there and take your lordships to the authorities bundle tab 3. And that is an extract from the Solicitors Act. I don't need to go to section 69, but I will go to section 70 at page 10. Section 70 is when the client applies. Section 71, as your lordships know, is when someone else applies. The only reason I go to section 70 is just to make the general point that there's a gradation here. The client has a month when he or she can apply as a right. Then there's a period where there's a general discretion, and then you get to a point where there are special circumstances required to be demonstrated. And ultimately, once the bill has been paid more than a year ago, the court doesn't have any jurisdiction to order an assessment at all. I don't need to go to that line by line. I do just want to draw attention to section 70, subsection 2, which is dealing with conditions where no application is made on a month, within a month. That's the automatic as of right. The penultimate line of the first body of text, the court may, on such terms as any, as it thinks fit. And I just want to draw attention to the way that such terms is used in that section, because I say it informs what such terms means in section 71 and actually gives an immediate answer to one of the live points on this appeal. So subsection 71, which is on page 12, and we are today concerned with what, if any, differences there are in the approach under subsection 1, which is what Tim Martin dealt with on its facts, and subsection 3, where I say it also dealt with that in its approach, although that wasn't the subsection engaged on the facts. And in subsection 1, we see that, and I paraphrase a bit, a person other than the party chargeable is liable to pay, then that person, etc., may apply to the High Court for an order for the assessment of the bill as if he were the party chargeable, and the court may make the same order as it might have made if the application had been made by the party chargeable with the bill. And that is, if we look at it carefully in my submission, when the subsection there says that as if he were, the court may make the same order as it might have made on the application, that making of the same order isn't a reference to what happens when the assessment takes place. It's a reference to making the order for the assessment, i.e. ordering that there shall be a Solicitors Act assessment. And so, as if he were the party chargeable payable, the court may make the same order as it might have made. That is referring to the criteria the court applies in deciding whether or not to order an assessment, and if so, upon what terms. It's not directly speaking to how the assessment is conducted. And that is why those words don't appear in subsection 3. Because in subsection 3, subsection A, the bill be assessed on such terms as it thinks fit. So under subsection 3, the criteria for deciding whether or not to grant an assessment aren't necessarily the same as those to be employed if it's the client himself asking for an assessment. That says nothing about how the assessment itself is conducted. And we see that point also reiterated in subsection 4, that in considering any application under subsection 3, the court will have regard to the provisions of section 70 as to applications by the party chargeable for the assessment for solicitor's bill, so far as they are capable of being applied to an assessment made under that subsection. So what we emerge from the statute with is that there may be a difference between subsection 1 and subsection 3 as to the way the court approaches the question whether or not to order an assessment, and if so, on what terms. But there's no indication there that once you get to an assessment, a different approach is to be taken. And indeed, in my submission, that must be right from first principles, because essentially what the Solicitors Act, and this part of it is designed to address, is the question, are the solicitor's charges reasonable? The focus isn't a trustee or an executor. The focus is the solicitors, and the ultimate question is, are the solicitor's charges reasonable? And subject to certain narrowly defined exceptions, the answer to that, where third parties can take particular points, but fundamentally, the answer to the question, are the solicitor's charges reasonable, cannot and does not depend on who is asking the question. Either the solicitor has conducted itself reasonably or it hasn't, and the outcome, as a general proposition, doesn't depend on who it is who is challenging the solicitor's charges. There are just two narrow exceptions to that, as I dare say your lordships have already seen in Tim Martin. But that general point is that it doesn't matter who is asking the question. Before I go to Tim Martin itself, I want to go to the case about which I think there's probably the most debate between the parties, and it's referred to at length in Tim Martin, and it's a short judgment, but I do just want to show the court the judgment itself in Ray Brown, and that's tab 9 of the authorities bundle. This is a case where Mr. Brown acted as solicitor for the trustee. He delivered his bill and it was paid in full, and the solicitor sought an assessment. The beneficiary sought an assessment. The solicitor complained that the beneficiary's recourse was against the trustee. And it was actually, to be clear, the solicitor who was taking this point on appeal, and it was only the solicitor whose counsel was heard from, and he lost. Just one point, and we might just need to come back to this.
Could you just repeat that? I didn't quite follow that.
It was the solicitor was the appellant in this case.
Yep.
And it's in fact only the solicitor's barrister who was called on, and he lost, because what Lord Romilly essentially said is that's the general position, but there is an exception. And I submit the only way one makes sense of this case is he was saying that the solicitor fell into the exception to the general rule, and therefore there could be an adjustment at the behest of the beneficiary. There is, as is commented on in the skeletons just before we get to the short judgment, on page 26, the report says that the bill has been taxed under section 38. That's a bit puzzling, because section 38 is the predecessor of subsection 1, and Lord Justice Lloyd regarded this as a section 39, i.e. the predecessor to subsection 3 case. And there's no entirely obvious answer. It may have just been a mistake in the way that it was recorded, but I will come back to that. But this was undoubtedly a beneficiary seeking an assessment. And what Lord Romilly says at page 27, he agrees with Mr. Little, who's the barrister for the solicitor, that under the third party clause, that's section 38/39, the person who taxes the solicitor's bill must tax it exactly as if he stood in the place of the trustee, i.e. the client, and that therefore it is a taxation between solicitor and client. And then we get to the qualification. So Lord Romilly confirms in terms, to use that shorthand, that the beneficiary stands in the shoes of the trustee client, but with the following qualification. And I know your lordship has had a chance to look at this, so I'm not going to read this all out unless that would be helpful. But the gist of it is that if a client comes along and says and asks the solicitor to do something that serves no useful purpose, to borrow the phrase, you can have them if you wish, but they're not at all wanted. They are of no species of use. But the client says, never mind, do it. The solicitor does it and charges the client. But if the client is a trustee, he makes the same request, but he's a trustee, and the client says, and the solicitor says it's no use, and the client says, I insist on it, then the key thing about 3/4 of the way down page 27 is this. Very well, if you insist on it's being done, it shall be done, but you must understand that this is not required for the purposes of the administration of the trust. You cannot charge these costs against your beneficiary, and I cannot put them in the bill of costs, which will have to be paid out of the trust estate. So there we see one exception to the general principle that the beneficiary stands in the client's shoes. If it's something, and I note, I'd invite the court to note that this is a narrow exception. If the trustee asks the solicitor to do something where the solicitor then has a professional obligation to say, you really can't lay this at the estate's door, and the trustee says, nevertheless, get on and do it, then when the beneficiary, and then if the solicitor goes ahead nonetheless and puts it in the bill to the estate, the beneficiary can take that point against the solicitor. And my submission is that is what is in the later cases called a special arrangement situation, where the client can, where the client can only authorise the solicitor to do it on a special arrangements basis that doesn't bind the beneficiary. But it's a narrow exception, and it does not support the proposition that's advanced on the opposite side of the court, that the court can reduce the amount of illegitimate charges. It's a question of disallowing things in principle, not simply reducing the amount. And we will see when we get to Tim Martin that reductions of amounts, in my submission at least, aren't allowed. So this is dealing with a situation where effectively the solicitor, and we see this at top page 28, I think therefore it's the duty of the solicitor to tell the trustee, this is not wanted for the administration of the trust, and if you insist upon it being done, it's for your private convenience. So in that situation, if the solicitor then bills the estate, the beneficiary can complain. But it's a narrow exception. So my lords, against that I'm going to come straight to Tim Martin, which is at tab 17 of your lordship's bundle. This is really the key case.
Just before you leave,
My lord, yes.
read Brown. Probably the end of his judgment does deal with quantum, and it would appear that the taxing master has looked at number of attendances, amount allowed, and so on and so forth. And he says, well, you can't take those sort of points into appeal because the court always allows the opinion of the taxing master.
Yes, he talks. I'm so sorry, my lord.
So it would seem that on this third-party assessment, the taxing master had reduced the quantum.
Well, they draw a distinction. Yes, your lordship's right to raise that. They draw a distinction between quantum and quoties, which I'm not sure is a word we use very much anymore. But I take that to mean, and I think this is confirmed by the example that follows the use of that word, whether you shall allow 10 or 12 interviews, that it means how many or how often.
Yes.
I agree that your lordship is right to say that that could be interpreted as meaning that there are adjustments to amounts. I would submit two things. One is that it's actually, firstly, it's disallowing items altogether. It's not a question of saying this interview costs too much. It's a question of disallowing potentially one or two of the interviews. But secondly, the only way in my submission that can be made sense of in the context of what has happened before, where they say it has to be a category of cost that the solicitor has to warn the client about. So you can't get me to do this because it's not in the interest of the estate, and if you insist on it, you can't ask me to bill it to the estate. That's clearly talking about a category, not the amount or level. I think, therefore, I submit, therefore, that what's being said in the final paragraph is that it was up to the taxing master to draw the line between those interviews, for example, that were properly chargeable to the estate and those that weren't. And one of the things about this report is we don't actually know in any detail what it is that the beneficiary was complaining about.
Well, we know a little bit because if you look at the submissions of counsel, bottom of the first page, page 26, if it was improper in the trustee to require the solicitor to write so many letters or to attend upon them so often, the remedy is to object to the allowance of the items in the account between the trustee and himself.
Yes.
That suggests that one of the complaints was, well, you've written all these letters, you really didn't need to do it in terms of the administration of the trust.
And that's the point that the beneficiary has to take against the trustee, not one he can take against the solicitor. In my
that's the submission of counsel.
Yes.
As I read the judgment, that's rejected by Lord Romilly. Because otherwise, I can't understand what he's saying in the final paragraph.
Well, I mean, I agree. It's not helped by the fact that we don't know exactly what was being, what exactly was being objected to. But I say one thing is clear, is that the question is the disallowance of items in total. It's not a question of adjusting their amount. But I think your lordship is putting to me, and I think we can see that at page 26. The object of the application was to obtain allowance of the items.
Well, you can see what the taxing master disallowed in the head note. Disallowed in particular charges for certain attendances upon the trustee and for letters written. Those are the particular things. I mean,
Yes.
that's not everything. So, let's take attendances upon the trustee. And reading with that, with the final paragraph, the question is, he's charged for 12 attendances or interviews, and the taxi master says, I'm going to allow 10. Now, that doesn't seem to me to be very different from saying what's a reasonable amount to charge for attending on the client.
I mean, I do say there is a difference between saying the interview should not have happened and the interview was too expensive. And I do say...
Why? I mean, suppose he's charged for a 3-hour interview and the taxi master thinks, well, that's just spinning it out. He could have done his business in an hour. Why is that a different... Why is the fund... Your submission is, and I see... We're going to go to Tim Martin. I see where you get it from, Tim Martin. But your submission is there's a fundamental difference in this judgment between saying this is not something you can charge to the estate at all, and saying, well, you can charge for some of it, but you can't charge for all of it. And I don't see that distinction in the judgment.
Well, I say it comes from the fact that what's being challenged is whether or not items are in or out as a whole. And it may be, I mean, what the Lord Romilly is hypothecating, for example, is, okay, you can have this interview if you want, you can have this attendance, but it's a complete waste of the estate's money. And I, the solicitor, have to warn you that you can't charge it to the estate. And that I say is the line between saying that on the one hand and saying on the other hand, well, that interview went on. That interview was appropriate, but it was inefficiently conducted.
But doesn't that ultimately just come down to a question of presentation? I mean, you could present that as being there's a claim for £1,000 for attendances, and the taxi master said that's too much. I shall allow £750. And then how do you get to that? Well, I knock off 3 of the attendances. You could present that as being, well, that's an all or nothing point for those 3, or you could present it as being a matter of quantum. And there's no real distinction between those 2 approaches in Lord Romilly's judgment. I think that's really
He doesn't draw that distinction. I mean, I'm inferring that he doesn't draw that distinction. I do say when we come to Tim Martin, that distinction is very clearly drawn. So, perhaps I ought just make this fallback submission that if I'm wrong about what In re Brown says, there is a discussion, as we will see in Tim Martin, about how solicitors' charges are now done very differently from the way they were in those days. And the comment is made that in those days, often it was fixed items, it wasn't hours and hourly rates. So even if Ray Brown was right in the context it was decided, it no longer reflects the law, is my fallback submission.
Well, I understand that, and I think we're all labouring under the difficulty that we don't really understand quite how things worked almost 200 years ago, 150 years ago. But I'll let you go in a minute. But I do want to understand what it is you say Lord Romilly is actually deciding in this case. And going back again to the final paragraph, he not only deals with what it is, how many interviews, he says that's a matter for the taxi master and we're not going to interfere, should it be 10 or 12, but he assimilates that to the question of quantum. Should he allow 13 shillings and 4 pence or 6 shillings and 8 pence for an interview? Now that does look very much to me like saying, well, what quantum is appropriate for the solicitor to charge the estate for doing a particular bit of work. And there's no suggestion there that the question is this estate work or not estate work? The suggestion is, how much is it worth? And that's a matter on which the taxing master's opinion is paramount. And I find it difficult to see from this judgment as a whole the distinction you seek to draw between saying there are things you do which aren't really estate business at all, which can be struck out, and there's a question of quantum which is not open to be taken on the assessment.
Well, I mean, I get the first point from page, I see it submit that I get the first point from page 27, the example that where the solicitor's got a duty to say, well, I'll do this if you want, but it's of no species of use, and you can't, and I can't bill I can't bill the estate for that. The second point, I accept. I mean, I do accept that given there was no question of quantum seemingly canvassed before the court, it was simply a question where the solicitor was coming and saying these items have been disallowed. Will you on appeal please allow them? And I infer from that, because they obviously weren't reintroduced into the bill, I infer from that they fall into Lord Romilly's category of the solicitor should have warned the trustee that these were of no use and that the estate couldn't be charged. So those were items that were out in principle. I do accept against that the discussion of quantum is harder to explain. But as I say, firstly, it's clear that the issue here was items in or out as a whole. And that was the solicitor's challenge, that things have been, I do accept it's hard to see from that where the question of the taxi master's skill on quantification comes into it. I do see that, and I have puzzled over that. But I think the best answer I can give is that even if one says, well, items are in or out as a whole, perhaps coming back to my Lord Justice Coulson's point, that there is an element, there's still a line to be drawn. And if there are some attendances that deal with estate matters, and let me take a ridiculous example, some attendances or parts of attendances where the executor is asking the solicitor about a neighbour's dispute, as I say, I take a ridiculous example. It may be that the taxi master has to draw the line as, okay, for the first 30 minutes, you were talking about the estate, but for the last 30 minutes, you were trying to get some advice about your argument with your neighbour. That's got to come out. No,
So it's a nice idea for your case.
No, but I mean, I think I can say neutrally that there's no real indication in this judgment at all about what the objection was. So I accept I've taken an extreme example that would illustrate my point, but it's that I submit is in answer to the question of the court's understanding of Passmore, the only way that you can reconcile the last paragraph with what goes before is that the taxing master had to draw the line. Some interviews were to do with the estate, others weren't.
Thank you.
So, my lords, I will go to Tim Martin, which is at tab 17. So this, of course, as your lordships know, is a situation where the mortgagee, who had a right to recover its solicitor's costs from the mortgagor, instructed the solicitors, the fees were paid, and the mortgagor objected. Now, I know your lordships have had the opportunity to read this, so I will try not to take too long on it, but it is the key authority. After this, everything else will take less time, except perhaps some comments on the cost judge's judgment itself. So the question is put in paragraph 14 at page 108 to consider whether there's a separate basis of third-party liability. That, of course, is the question. And I just draw attention before we get into the meat of the judgment in terms of whether whether the client could still take the point. And I'm going to move straight on to page 114. And paragraph 40, sorry, forgive me, paragraph 39, letter B. This isn't the Ray Brown case, this is an earlier case. Again, it's Lord Romilly. It's the case with Ray Massey. But at letter B of paragraph 114, just below that, Lord Justice Lloyd says this, the Master of the Rolls held that the clients having paid voluntarily and with full knowledge, and I'll come back to the facts that how that applies here, could not have the solicitor's cost tax, and that the third party could not do so either. I do just in a few places want to flag up that the fact that the client had paid was a central point to Lord Justice Lloyd's approach, because I do say on the cost judge's approach, if he was right, the fact of payment would make no difference whatsoever. And I'll come to that, but that's inconsistent with Tim Martin. And then at paragraph 40, and I don't need to take too long on this because we've been over it, raising the question of Ray Brown itself. As I said before, there seems to be some confusion as to whether it really was a Section 38 or a Section 39 case. But what Lord Justice Lloyd says is he had to consider a taxation under Section 38 of the bill. And then he says Section 39 was the predecessor, which appears to govern such a process. But this is important, but nothing seems to turn on whether it was a Section 38, whether it was Section 38 or Section 39 that was relevant. And that's a direct statement, in effect, that nothing turns on whether it's Section 71.
Nothing seems to turn.
Nothing seems to turn on whether
Without any further explanation as to why nothing seems to turn. Because this appeal says a lot turns on it.
Yes.
Because we're under Section 71(3). And so we need to look at Section 71(3). So he says nothing seems to turn for the purposes of In re Brown. But Lord Romilly refers to a third-party clause. That could only be Section 39 of the previous legislation, couldn't it?
Third-party clause.
I mean, that's his. I took that to be his shorthand.
I think that must be right.
And so the reference to Section 38 is not uncommonly in Victorian law reports an error.
An error. It would
At least
seem
it's not the sort of errors that you do sometimes see where they omit the word "not." But it is on the face of it, it looks
wrong.
like an error.
It looks wrong. But I mean, yes, your lordship was right to say he says nothing seems to turn. But what he's saying there is that the approach would be the same, whichever it was.
Can we clarify two things?
My lord, of course. I'll try.
Would you accept that anything that Lord Justice Lloyd said about 71(3) is strictly obiter?
Actually, my lord, I wouldn't.
You wouldn't. Okay,
I wouldn't,
fine. We'll
because
explain that now or later.
But let me come to that now. I mean, we go through this, and the whole focus of the case, the point that's made by reference to the authorities repeatedly, is that because the ratio of the case in my submission essentially is that a third party, subject to established and narrow exceptions, a third party can only stand in the shoes of the client. And that follows, that applies equally to subsection 3 as subsection 1. And the reason for that, as I endeavoured to submit at the outset, is that the question is the reasonableness of the solicitor. And that can't depend on who's asking that question.
Why not? I'm sorry, I didn't.
You didn't stop me
Didn't stop
before
you,
you're going to stop me now.
But now that you've said it again, right? Why not?
That was a mistake.
Because Re Brown illustrates that if a trustee says to his solicitor, I want you to write a letter to X, that may be a perfectly reasonable charge for the solicitor to charge the trustee with, because the trustee is his client and he's done what the client asked him to do. But it may not be a perfectly reasonable charge for the solicitor to charge the estate with if it's one of those letters where the solicitor really ought to have said, actually, this isn't really needed for administration of the estate, and if you want me to do it, you'll have to pay for it yourself. So the very same question, is the solicitor's charge reasonable, may get one answer if the question is asked by the client, and a different answer if asked by the beneficiary. So I do take issue with your fundamental question.
Two responses, if I may, to that. The first is that in the Ray Brown example, the solicitor had behaved unreasonably, or at least wrongly, on the facts as I would interpret them, because it seems he didn't say to the trustee, I'll do this if you want, but I can't bill it to the estate, because it seems that he did bill it to the estate, hence the case. So that unreasonableness of the solicitor was by inference at least, or wrong, or that he'd done something wrong, was part of the factual matrix in Ray Brown. So he had behaved unreasonably because he clearly didn't say to the trustee, I'll do this if you want, but I can't bill it to the estate. One infers because he did bill it to the estate and then the beneficiary objected. But
successfully objected.
Successfully. But that's the first point, that it did involve unreasonableness, or at least doing something wrong on the solicitor's part. It wasn't that the solicitor hadn't done anything wrong, and it was simply a different person asking the question. Now, in that, but my second point is this is an established narrow exception that doesn't undermine the general approach that the assessment is the same whoever is asking for it, that there is a particular category, and I will say that this is what Lord Justice Lloyd is referring to when he talks to special arrangements. There is a particular category of costs that can't be charged to a third party, but that category is basically costs where the solicitor should have, but failed to, one, give the client a warning that they couldn't charge the third party, and two, shouldn't have submitted a bill that was payable out of the third party's funds. But that's a specific narrow exception in my submission, and it doesn't undermine the general principle that when you're looking at what the solicitor did, etc., how much you charge for this and that, that the question has to be, the answer has to be the same, whoever's raising the challenge. And it's, in my submission, subject to sort of various, and this is why I made the point that actually in Ray Brown, the solicitor had done something unreasonable or at least wrong, as best we can tell from the report. It is in my submission conceptually difficult for the solicitor, either the solicitor was reasonable or it wasn't. And I take your lordship's point, if the solicitor's told to do this, etc., then then he does it, then his prima facie at least behaved reasonably. But that doesn't depend on who's asking the question. It's conceptually difficult to say, well, if the question's asked by one person, it was reasonable. If the question's asked by another person, it was unreasonable.
I don't myself find it difficult at all. I think they're different questions. I think one question is, what can the solicitor charge the client? And the separate question is, what can the solicitor charge the fund? And it may well be that a solicitor who knows he's acting for a trustee, as the ought to be giving advice to his client, the trustee, on every issue as to whether it's properly chargeable to the fund or not. But the solicitor doesn't do that. The solicitor just charges the trustee and says these are my fees. But if the client, who has no personal incentive to limit the fees at all, doesn't challenge it, the statute gives the beneficiary, who does pay for it, the right to challenge it. And I don't see why the two questions shouldn't give different answers, namely what can the solicitor properly charge the client and what can the solicitor properly charge the fund? They're not the same question.
Well, I would say that
Are
two
they?
questions, because there's not a question, I would say there's not a separate question of what can the solicitor properly charge the fund, subject to the Ray Brown narrow special, what I've called a special arrangement. If I can just call it for shorthand, the Ray Brown exception, if your lordship knows what I mean by that. Subject to that, there isn't a separate question, what does the solicitor charge the fund? The solicitor's client is the trustee. The separate question, and this is the answer given in Tim Lloyd, the separate question is, what can the beneficiary challenge as against the trustee? Because the solicitor can only do one thing. He can't say, I mean, either the solicitor does the bit of work or he doesn't. He can't say, well, I'll do it from the perspective of the trustee, but I'm not doing it from the perspective of the beneficiary. The solicitor has to do one thing, and there's really only one challenge that can be made, and that's the challenge the client can make. If the client, so there's no separate question of what the solicitor can charge the estate. The separate question is what can the trustee charge the estate? And that is not to be done under the Solicitors Act. That's a question of the beneficiary getting an account against the trustee. And perhaps, as your lordships have raised this, I'll just make this submission now, that there is, running through the theme of the cost judge's judgment, essentially an express concern that, as against the trustee, the beneficiary might not get very far, and he might find it difficult to get an account against the trustee, and therefore the Solicitors Act somehow steps in and augments that right. I mean, that's paradoxical, given the Tim Martin decision, which says actually the third party's right under the Solicitors Act is extremely narrow, and therefore the third party might want to go for an account against the client. But also that isn't some kind of procedural gap that or some kind of deficiency that by straining its approach, the Solicitors Act should plug. The position the law has consciously developed, and I'm sure your lordship knows this much better than I do, is that beneficiaries and trustees have certain rights against each other and certain protections from each other. And it may very well be that there are cases where a beneficiary is aggrieved and they have no remedy at all. But that's not a gap in the law for the Solicitors Act to plug. That's because the law has consciously reached a position that a trustee is allowed, if I can put it very loosely, a certain amount of latitude and discretion within which he can't be challenged by a beneficiary. But that's not some deficiency to be plugged by the Solicitors Act. That's the position the law has consciously reached. And there's a further point I would make about seeing the beneficiary essentially, as I think my learned friends put it, as the ultimate client, that, again, as your lordship may know better than I do, it must be a fallacy to regard the beneficiaries, plural, as some homogeneous entity. They may have conflicting interests. It may be that one of them has an interest in a solicitor, so a trust, the executor spending some money getting advice on a particular point. Other beneficiaries, because of the way the will is structured, may have no interest in that at all. They may be squabbling amongst each other. They're not some homogeneous entity that can be regarded as the ultimate client.
Mr. Marvin, I think you were addressing the question from my Lord Justice Stuart-Smith about whether Tim Martin, whether you accepted it was obiter.
And I said no.
And you said no. And you said there were two reasons. And the first, you've developed and you made your submissions about whether or not there are two different questions and standing in the shoes which we have. Was there a second reason? Did I note down?
No, I'm sorry if I said that was my reason.
That was your reason.
I'm
Fine.
sorry if I
No,
said there was a second
that's
reason. I'm
absolutely
sorry
fine.
to have kept your lordship in suspense.
No, no,
If it comes back to me, I'll mention it, but I think I only
I
have one
lived
reason.
with it and I managed to curb my excitement, but I just thought that I would make sure. So that's the reason why you say what he says about 71
Must apply to
applies
73.
equally to 1 and 3. You say
71.
so that what he says about 71.3 is not Overton.
Yes.
Yeah, understand that.
I have one other question.
My lord, yes.
That sentence or that phrase in paragraph 40, line 5, has the look of a throwaway line. Tim Martin is a very densely reasoned judgment
Yes.
on all matters except this, which suggests that the point was not taken. Because if the point had been taken,
Except it didn't arise. Subsection 3 wasn't in
it
it.
certainly didn't arise, but was not taken. It was not taken because I just find it hard to believe that Lord Justice Lloyd would have just swatted it away like that if he had received submissions that there was a difference between 71 and 73, 71.1 and 71.3.
I mean, I think I'd have to accept that it's obvious no one was arguing that there was a difference. That's not, I hope, quite the same as me saying that it's embraced within the ratio. And that we will see there are other examples where I submit it's clear he's referring to section 71 as a whole, not merely subsection 1. But my overarching point is that what underpins this is the question that's being asked and the fact that whoever is asking it can't really, subject to narrow exceptions, do anything other than be in the client's shoes. But can I just make one, if it's not an overdeveloped point, that I would on this try to have my cake and eat it, because if it did make a difference, and if Ray Brown really was, and I don't see how it was, but if Ray Brown really was an assessment under section 38, then we would have the extraordinary position that if a beneficiary goes under section 38, they get one sort of assessment, and if they go under section 39, they would get a different sort of assessment if the master's right. And I say that can't possibly be right.
Could they go under section 38?
Well,
What, under section 71.1 now?
I don't think they could.
That's how I read it.
But I'm simply saying if the report's right, the beneficiary could, if I'm wrong about, if your lordship and I are both wrong about that, and the beneficiary could go under what was then section 38, it would be extraordinary if he got a totally different assessment under section 38 to the one he would have got under section 39. Is your lordship going back to the Act?
This shall be liable to pay or shall have paid. The beneficiary doesn't. It's not
No.
liable to pay. And
It comes out of the estate. No, I'm not suggesting that. I'm simply saying that if the report is right that it's section 38, you couldn't have the extraordinary position that the beneficiary gets one form of assessment under section 38, but if he'd opted for section 39, he'd have got a different and more expansive one. So I don't really need to say much more about paragraph 40 because we've looked at Ray Brown already. And then if I go to page 117 and paragraph 46, and I do just draw attention to the quotation at letter E from In Re Gray, and I won't read it out, but it effectively says if as a category matter the item's correctly in the bill, they can't object that the amount of the payment, if it's sanctioned by the client, is excessive.
That's a section 38 case.
That's a section 38 case, yes. And then I'm going to jump through quite a lot, if I may, to page 125. And in particular paragraphs 68 and 69. And paragraph 68 and 69, in particular 69, 68 discusses the court may make the same order, if any, as might have been made if the application had been made by the client. I've made my submission, that's really talking about the order for the assessment, not the approach of the assessment. But then in paragraph 69, again, I wanted to come back to this, the light of the questions the court's put to me. It is clear from paragraph 69 that Lord Justice Lloyd is, at least so far as he is concerned, not seeing any difference between the subsections, because he's talking about just above letter F and just below letter F. He's talking about section 71 as a whole. And that, of course, in a modern report and in drafted judgments in writing, that's not a typing error. And as your lordships have said, it's a carefully reasoned judgment. I do take my Lord Justice Stuart-Smith's point that no one was putting the contrary proposition to him, but it's clear that he thought, Lord Justice Lloyd thought, what he was saying applied to the whole of section 71.
Well, is that right? That assumes that the second sentence of 69 is referring to 71.1 and 71.3.
It is assuming that, yes, but
why do you think?
Because if one reads further down, so his lordship says, apart from the fact that an assessment under section 71 must be limited to costs which the third party is liable to pay, which may be more restricted in scope than those which the client is liable to pay to solicitor, the certificate resulting from assessment under section 71 must be for the same amount as would have been, etc. So I say it's not an assumption, one can see that from later in the paragraph that he's talking about that section as a whole.
Thank you.
And although this comes at it from a slightly different direction, one sees the same point in paragraph 71, when he gives examples of cases under, well, he says section 38, but he does include, and I appreciate what your lordship has put to me about the difficulty of a beneficiary going under section 38, but that may be just a reference back to the confusion in Ray Brown, but he does include amongst the examples, without giving any suggestion that a different approach applies, at the very end, trustee and beneficiary.
Other than in Ray Brown, are there any of those authorities that are trustee and beneficiary?
No, they all seem to be the old cases all seem to be section 38.
Yeah. So, but for the potential typing error, in Ray Brown is the only one under section 39.
Yes, my lord, that's right. But when one comes, and I'm going to turn the page now, if I may, to page 126, to the discussion, because having gone through the authorities, that he discusses their effect. Again, assuming that Ray Brown was a section 39 case, and Lord Justice Lloyd seemed to think that it ought to have been, the first broad point I will make is that when he discusses Ray Brown, and he says that some of the cases point in slightly different directions, he doesn't draw any distinction. And says, well, some of what I'm saying, some of what I'm getting from Ray Brown might not be on point.
Where are you?
I was just making a general point. I've turned to page 126, but before I jump back into the text, which I will in just a moment, starting at paragraph 73, I just want to make the point that Lord Justice Lloyd speaks of Ray Brown in the same breath, so to speak, as he speaks of all the other older cases, without suggesting, well, that might have been different because it was a beneficiary case. I'm sorry, can I just go back, because I've just been reminded of something that I may have, sorry, I won't interrupt it. So I'll come to paragraph 73. So in paragraph 73, he refers to essentially the tension developed in the course of the case, starting within Ray Brown. So that's the starting point, in which the judges found a number of ways of ameliorating the effects, the limitation on third-party taxation and the effect of the third party's undertaking to pay the sum found due. One which is not controversial is that is to be excluded from the bill anything relating to a matter for which the third party is not liable at all. So that's my ridiculous example where the executor tries to get some advice on a boundary dispute or something. and then he gives a sort of slightly more plausible, there's a slightly more plausible example in that case. Again, he talks in that section about section 71 rather than any particular subsection. And then, and I ought to go to this at paragraph 74, he did say that some of the older cases disallowed matters, disallowing, and I just stress it's disallowing, not disallowing and or reducing matters as excessive and unreasonable. And he gives us an example of that, pleading settled by leading counsel. He says there the justification is different. It is not that it was incurred on a matter for the cost for which the third party is not liable at all, but that the third party's liability is limited to that which is reasonably and properly incurred, and in particular that it does not extend to items which, as between solicitor and client, would only be recoverable on the basis of special authority given after proper advice. And then the possibility of such items being called into question is not in doubt. And the presumption, and I'll come back, I'll show your lordships this presumption in the revised CPR in a little while. But that presumption is directly on point in such, those presumptions are directly on point. A third party cannot be at risk of being liable to the client for a sum which is only recoverable by the solicitor from the client if the solicitor advised the client that it would not be recoverable from the third party. And that's his summation of where the older cases got to. I will say that even if it's not absolutely clear from that passage, when we get later to where Lord Justice Lloyd pulls it all together and says where we are now, it's clear he's talking about disallowing items, not reducing amounts. Because he then goes on, and I don't think I need to read this out, at paragraph 76, to say, well, the way solicitors charge now is really very different from the way they charged before, and it's all hours and hourly rates. And you can't just take one, you may not be able to just take one fee and knock it out altogether. And then on page 128, starting at paragraph 81, none of the older cases seem to show that the court allowed the recovery of a lesser amount for some item in the bill on the basis that some expenditure on it was proper, but that too much had been claimed. The cases all appear to me to show that the items were either allowed or disallowed in whole. And that's part of his conclusion from the old cases. I don't need to read the rest of that paragraph, but in 82, his lordship says, neither on the basis of precedent, therefore, nor as a matter of principle, does it seem to me that it's open to the court on an assessment under section 71, again I flag he's talking about the assessment, the section as a whole, to substitute a lower amount for a higher one on the basis that something is allowable, but that the rate claimed is unreasonably high, unless that substitution could have been made on an assessment under section 70 as well. Where the client has agreed the bill and paid it, such a substitution is not possible under section 70. And then we get to probably one of the two most important paragraphs in the judgment, which is paragraph 83. Thus I accept, and that this is the beneficiary's argument, to the extent but no further, that on an assessment under section 71, again no subsection, the court can strike out of a bill A, any item which relates to business for which the third party is not liable at all, e.g. here the bankruptcy, which was outside the scope of liability under the mortgages. B, any item which, and I underline this bit, as a whole, would only be allowable as against the client on the basis of advice that it would not be recoverable against the third party, and therefore is to be treated as subject to a special arrangement between solicitor and client. And I say that that's where Ray Brown fits in, that the warning that should have been given, etc., would have been a special arrangement. I do not accept that either the cases or the statute allow for the court to alter the amount of an item in the bill in respect of which something is properly chargeable, where the court considers the amount claimed excessive and unreasonable, so that a lower amount should have been allowed, unless that could have been done on assessment under section 70, as between the solicitor and the client. And then he quotes what Mr. Justice Lewison, as he then was, said in the judgment under appeal.
Why couldn't it be done on an assessment under section 70?
Well, this will come. We'll come to the point where what could
Could be done under
could be
section
done.
70. Because section 70 contemplates the solicitor delivers a bill to the client, no third party involved, and the client can, as of right, have it assessed within a month.
Within a month, yes. But there's a temporal element to this. And this is why I've drawn attention in two places. The fact that Lord Justice Lloyd said the client couldn't take the point because they had paid the bill. And I'll come to this when we look at the Master's judgment. He's not talking about, I say the Master's wrong to think that what Lord Justice Lloyd is talking about is the kind of points that a client could have taken at some point. He's talking about points that are still open to the client at the point at which the beneficiary seeks an assessment. Because otherwise, payment would be completely irrelevant. Because your Lordship's right. I mean, obviously, there might be restrictions if the client of what the client can realistically do if he's signed up to certain terms and conditions. But at some point, the client could have said, I don't like your hourly rates, they're too high. At some point, the client should have said, I don't want you to keep on using this level of fee earner. Use a lower one.
I mean, the client might well have signed up to an hourly rate because you when you instruct solicitors, they send you a letter saying, we propose to use so-and-so and their hourly rate's £400 an hour. And please sign and return it. So you might well have in the retainer an hourly rate, but when you get a bill and you've spent 12 hours perusing the will and deciding what it means, the client surely is entitled to say,
yes,
it couldn't have taken you 12 hours to do that.
Yes, but if the client doesn't do that and then pays and thereby approves in that sense, and I'll come back to what approval means, but if the client doesn't do that and then pays and approves and pays the bill, the client, subject perhaps to special circumstances, couldn't then take the point.
But can the beneficiary take the point?
No, not then. That's why it's because this is where I say the Master got it wrong. Because we've seen in at least two places very clearly Lord Justice Lloyd makes the point that the client couldn't take the point because the client has paid the bill. And we had that in... sorry, I've lost my places, but...
82.
82, I'm very grateful.
Agreed the bill and paid it.
Yes. And it was earlier, I think, at paragraph... sorry, I've lost my place again, but I'll come... There was an earlier, I'll come back to that later. There was an earlier point where he was commenting on one, he quoted from Lord Justice, yes, I'm sorry, sorry, it is page 114, letter B. The Master of the Rolls, Lord Romilly, held the client, having paid voluntarily and with full knowledge, could not have the solicitor's cost taxed, and that the third party could not do so either. So, I mean, I do say there's a temporal element to this, and because if one says, well, it's just the kind of point that the client could have taken, then the whole analysis in Tim Martin unravels, because at some point or another, the client could have taken any point.
Well, it unravels if you say that Tim Martin covers 71.3. It doesn't if not. Because you've referred a couple of times so the beneficiary couldn't take the point. Tim Martin isn't a beneficiary case.
No.
Tim Martin is a mortgagor case.
But that's...
So we are concerned with 71.3. I appreciate your submission is the same. The temporal submission, I think, is the same.
That's my point.
Yeah,
it would unravel under subsection 1 as well, because I can't see how, if my temporal point is wrong, it's equally wrong on subsection 1. If we just focus on 71.3, you say it's the same point because the client paid the bill, the client can't object. Because the client can't object, you say because it encompasses 71.3 as well, the beneficiary in this case can't object. Yes, but
that's the root.
That's the root, but they're two different questions. One is, does Tim Martin apply to subsection 3? But there's a separate question. I say the Master got this wrong. If Tim Martin does apply, to anything. Well, sorry, let me put it this way. When Tim Martin applies, how does it work? And on that question...
Well, no, I'm speaking for myself. I don't want to go there. The first question is, does Tim Martin apply to this case?
Yes.
Yes or no? And then if yes, the following arises. If no, the following arises. I don't think we want to be saying what happens if under 71(1), because this isn't a 71(1) case.
But it is part of the Master's judgment that when Tim Martin does apply, it still allows challenges to quantification of the kind that I say. And that comes from his distinction between points the client can take and points the client could have taken at some point. So I'm sorry if this is an unwelcome submission, but if the Master's, I do say if the Master's right on that, it has to apply whichever subsection you're going under, because that's not to do with the different wordings of subsections. That's to do with what Tim Martin says. And I say that what Tim Martin says is there's a temporal element to this, which is why there's an emphasis on the client can't take the point because the client's paid. If there wasn't a temporal element, payment would be completely irrelevant, because you could always say, well, before the client paid the bill, he might have said this and that within a month. At that point, if it's right on, I'm apologise if this is an unwelcome submission, but I do say that it's unavoidable that if the Master's right on that point, under subsection 3, it must also be right under subsection 1, because that's not a question of whether Tim Martin applies or not. That's a question of the Master's interpretation of what Tim Martin is saying when it does apply.
Understand that?
So, my lords, I think I was nearly through, and I was just going to go to really what's the ultimate. I don't need to do with the discussion under subsection 1 about payments unless I need to deal with anything in reply on that. I was going to go to the ultimate conclusion at paragraph 95 on page 131. And there, Lord Justice Lloyd just pulls together his conclusions, and he says, the effect of my conclusions as regards both quantification and payment is that the third-party assessment under section 71 is of limited use to a third party. As regards quantification, it only allows the cost judge to follow what might be called a blue pencil approach. He can eliminate A, items which ought not be laid at the door of the third party at all, because they are out with the scope of his liability here as mortgagor, and B, and I just stress, going back, this is eliminating, not reducing, from the third word in this sentence, items which are only allowable as between solicitor and client, and solicitor on a special arrangements basis within 4882C, and I'll come to that rule in just a moment. He cannot either eliminate any other item or reduce the quantum of any, not any other, any item, which is properly included in itself, but for which he considers that the charge made is excessive, unless he could have done so as between solicitor and client on an assessment under section 70. And just coming back to the point I was endeavouring to develop, the cost judge relied on the, so I won't try and remember which tense it is, but the phrase could have done so as suggesting that there wasn't a temporal element to this, and that what Lord Justice Lloyd meant was any point that at some, any challenge which at some point the client could have made. And I'd say that's an unfair use of the language, because this doesn't turn on the precise wording used. It turns on the substance of the analysis, and in particular the fact that Lord Justice Lloyd relied on the fact of payment as meaning that the client couldn't take the point and therefore the third party couldn't, which cannot work if there's no temporal element to this.
So do you say 95 is premised on the basis that the client has paid the bill?
Well, not quite, my lord. If I can just put it slightly differently, A and B don't really make it. Doesn't really matter whether the client has paid. It's the bit he cannot eliminate any other item or reduce the quantum of any item which is properly incurred, but for which he considers a charge excessive. So he can't make a general quantum challenge unless he could have done so as between solicitor and client. So it's not premised on there having been payment. If there hasn't been payment and the client could still take the point, then the third party could stand in the client's shoes.
So the payment point is encompassed by unless he could have done so.
Yes, unless he could have done so.
Yeah, and some-
And I do say that's not that can't be understood as meaning unless he could have done so at some point, because otherwise everything will unravel and everything is on the table for the third party. And it's also inconsistent with the reliance, I'm sorry, I've said this several times, the reliance Lord Justice Lloyd places on the fact of payment. That's totally inconsistent with saying there's no temporal element to this. And incidentally, the ultimate answer is if he's unhappy that and I think your lordships anticipate my point here, if the beneficiary is unhappy with the trustee or executor for signing off on a bill and the executor shouldn't have done so, then the beneficiary's remedy is against the executor but not the solicitor. And that's the taking out of an account, not a Solicitors Act assessment. So, my lords, just a quick word about that rule 48.82c, which is actually
Just
now.
before,
I'm sorry, my lord.
sorry.
Something's been troubling me, and I think I've understood what it is. If you go right back to section 70, which you started with, it gives the client the ability to tax assess a bill and a number of, as you said, hierarchy. First month you can do it as of right, and then after that, within 12 months, there's a discretion, and then you get special.
Unless you pay it. Once you pay it, it's special. After 12 months, or once you pay, it's special circumstances.
You can get a bill assessed after payment, as long as you do it within the next 12 months. Your submission is, once you've paid a bill, you can't have an assessment, but that flies in the face of what section.
Well, the client would have to the client would have to show special circumstances. So the client would have to, once the client's paid a bill, you get to special circumstances either after the bill is 12 months old or straight away after the client pays it. I can go back to the.
Yes, no, that's what it says. But
and then
what sort of special circumstances come within section 70, whatever it is, 3?
Well, I mean, that's very much an open texted question. Anything that the cost judge thinks is special. It's not as, on the authorities, it's not a closed list and it's not as high as exceptional.
Your submission on the basis of Tim Martin is that what Lord Justice Lloyd has decided is that once the client has paid the bill, he can't query the quantum. And therefore, once the client has paid the bill, the third party can't query the quantum.
And the client would need to show, I accept under the Solicitors Act, the client can if he can show special circumstances.
So mere payment can't be equivalent to that you lose your right to an assessment.
No,
you
I
could never challenge the assessment. So the mere payment, why can't the third party do what the client could do, which is ask for an assessment?
Well, because here, when we look at the points, I mean, the answer depends on the facts to that in my submission. Here, the answer is, and this is the final bit of my appeal, that the beneficiary wasn't able to raise even a prima facie case as to any item it could credibly have challenged. But there's another point here, which is that all but the last of the bills had been paid more than a year before the beneficiary made this challenge. So at the time the beneficiary made the challenge, only the very last in this sequence of bills could have been challenged by the executor.
And that's something that we should have regard to, because you'd have regard to section 70,
yeah.
But it's not determinative.
That's right, but you'd be left with the assessment of one last bill, in respect of which the client.
If it was section 70.
I'm sorry, for the clients. Yes, you have regard to the fact that yes, I'm not saying that.
Yeah,
but
the point I'm trying to clarify is that although that might be a showstopper as between the client and the solicitor, that is only something under section 70. That is only something to which we have to have regard
under subsection 70.
Under section 70. It's not a show. It's not
No,
a necessary showstopper.
My point on that is that it's the last point in the appeal is that the client on analysis didn't actually show anything where there was even, sorry, forgive me, the beneficiary on analysis didn't show anything where there was a prima facie case. And the only reason the cost judge thought the beneficiary did is because in my submission, he had misunderstood Tim Martin, because there is a section of the cost judge's judgment where he says, if Tim Martin does apply, I still don't think this assessment would be futile. But that's in my submission because he misunderstood what Tim Martin said. And he thought, in particular, that Tim Martin permitted adjustments to amounts in a way that, in my submission, it clearly doesn't. So,
If we're leaving Tim Martin, can I
of course not.
just ask you this, taking it back to potential basics. Section 71(3) is different to section 71(1). The words are different.
Yes.
On the face of it, if you knew nothing about the interesting Victorian history, you would think that 71(3) looks pretty wide. Assessed on such terms, if any, as it thinks fit.
But,
Now-
my lord, so forgive me for on that, I do say it's apparent from the way that such terms is used in section 70. That's not talking about what happens in the assessment. That's the conditions attached to
I
it.
understand that point, but
Thank you.
you agree that the words are different.
The words are different, yes.
We can debate whether they're wider or not, but they're certainly different. I think I'm right in saying that nowhere, perhaps for the reasons that we've already debated, is there any analysis of section 71(3), the words used in Tim Martin.
I agree with that, yes.
So this case is the first case that 71(3) will be the subject of construction and analysis.
Yes, I do agree with that. But my real point is...
Sorry, but just to finish that off, being an old-fashioned chap, it does strike me as going it a bit to say, well, you don't need to bother about the words because here's a case on a different subsection, which effectively means you don't have to trouble yourself and it's all covered by that case. Do you see what I mean? It traditionally, one looks at the words of the subsection and translates those into what you think those mean, and then take it from there. And you're not doing that because you say, well, it's all covered by Tim Martin because Lord Justice Lloyd referred to section 71 without differentiating between 1 and 3, and it's clear he thought they all meant the same thing.
Yes, but I mean, I suppose behind that, what I'm really saying is if you look at section 70 and section 71, actually, none of those sections is really saying how you conduct an assessment when you get into assessment. What they're all about, actually, the words of the statute, what they're all about is when you order an assessment and any conditions you attach to it. In fact, the statute doesn't really say anything about what you do when you get into the assessment. So I suppose what I'm really saying is it's not what you do when you get into the assessment is not really a question of construction of the statute. It's a question of determining the reasonableness of the solicitor's charges. That arises.
But it isn't on your case. You never get anywhere near the reasonableness of the solicitor's charges because the bill's been paid, the client can't challenge it, so the beneficiary can't challenge it.
Yes.
So it's no question of, as I understand it, this appeal is all about avoiding the need to look at the reasonableness of the solicitor's charges.
Yes, but the way I would put it is whatever agreement means, if the client agrees the charges, then they are to be regarded as reasonable because they've been signed off by the client. And if that was something the client shouldn't have done, then the beneficiary's recourse is against the client. So I do accept, and that's the point in Tim Martin in my submission. But I do accept that that I'm saying, but I say this follows from Tim Martin, that the beneficiary can't go back and take all kinds of points which the client, he can't disagree on things that the client's already agreed to.
And that then gives rise to my second point under section 71(3). The point is made in the respondent's skeleton argument, I think it's paragraph 45, that if you were right, 71(3) would have no effect at all because the trigger, which is the trustee being liable to pay a bill and then the beneficiary having the right to assess it, you say on your case, well, although that's the trigger, it's a meaningless trigger there would be no bang because the client's already paid it, so the client's already agreed it's reasonable.
I'll seek to grapple with that directly. Just a small preliminary point. It's actually, for what it's worth, and it's not my best or most important point, the liability to pay triggers. So you could have a window before the beneficiary pays, sorry, forgive me, before the executor pays where there isn't payment. But yes, I mean, I grasp that nettle, that it does mean that if the beneficiary, forgive me, I'll stop doing that, the executor pays promptly, then Section 71, subsection 3 is only of very limited use to the beneficiary. It's not of no use because the beneficiary can still take points about costs that are outside scope and can still take points about costs that could only be incurred by a special arrangement. So it's not useless, but it is, I entirely accept, of very limited and narrow use. But ultimately, I say that's just a complaint against the conclusion in Tim Martin. Tim Martin's point is that it is of limited use, and actually going for the solicitor is the wrong thing to be doing. You should be going for an account against the executor. But I don't shy away from that. I entirely accept that it's not completely useless, but it is of limited use, and I accept that. But I say that's what follows from Tim Martin, and I just also say that's right in principle, because otherwise you're blaming the solicitor for something that's the executor's fault. Okay, I'm putting that a little bit colour. I accept that's a little colour.
I think the vast audience that is tuning into this on live streaming might say, oh, hang on a minute, if the solicitor's fees are objectively unreasonably high, then it can't be said that that's the executor's fault for paying it.
Well, if the executor should have challenged the fees because they're too high, or shouldn't have agreed to a retainer that had astronomical fees in it, that is the executor's fault. The executor probably has a margin, and there are cases which we don't need to go to that says the executor doesn't have to go to the cheapest solicitor. But if the executor signs up to a retainer that's indefensible, that is the executor's fault. And I entirely accept there might be a gap between that, and there may be space between something that the executor can be blamed for and something that the beneficiary is entirely happy with. And this comes back to the point I was endeavouring to make to my Lord Justice Nugee, that that's not a gap to be plugged. That's because the law has developed in a way that gives trustees and executors certain protections. And if those protections are too generous, then that ought to be revisited. But it isn't an excuse for trying to shoehorn into the Solicitors Act or focus on the solicitor, something where if anyone should be the focus of criticism, it should be the executor.
So have I understood your submission correctly? There is a difference between fees that are reasonable and unreasonable for whatever reason, on the one hand, and an executor's the margin that is open to an executor to either react to those fees or not react to those fees. So your submission would mean that if a solicitor, of course not this case, if a solicitor had stacked his fees to a quite unreasonable amount, and the executor was a bit dozy on a Friday and passed it through, the third party beneficiary has no ability to challenge the level of fees.
Not against
the solicitor.
Not against the solicitor, but against the beneficiary.
The solicitor has the benefit of their unreasonable fees without challenge.
I'm sorry, my lord.
The solicitor is entitled to retain the unreasonable fees without them being subject to any effective challenge.
Well, if the beneficiary...
Because the executor was asleep on a Friday afternoon.
If the executor effectively says, I accept these fees as reasonable, pays them, signs off on them, then that's right, yes. The only challenge, it's only if the executor could take the point that the beneficiary could. And I don't shrink from that.
This has the net result that the solicitor is enriched beyond what he should do, and the executor is impoverished if he has a liability to the beneficiary.
If he's at fault, yes.
If he's at fault, well, he was asleep on a Friday afternoon.
If he incurs a liability, which is
maybe it's okay to be asleep on a Friday afternoon, but on the assumption that it isn't. But
yes.
that is, I just want to be. I'm behind the curve compared to my lords. I'm sure.
No, not at all.
But but that is the consequence of your submission.
Yes, that if Yes, absolutely. I don't show that. If the executor could have taken a point but didn't, and therefore, because the way things have read, no longer could, then the beneficiary can't take the point.
And you don't depend on Tim Martin for that conclusion.
Well, no, I do
You-
depend on Tim Martin for that. Because
You
Tim,
do.
Because-
I had the distinct impression that you were going so far as to say that leave aside Tim Martin, that's the natural consequence of proper interpretation of sections 70 and 71.
No, I'm sorry, forgive me. I'm saying that's the natural consequence of Tim Martin. Tim Martin says that it uses the generic term third party can't take the point. I'm actually saying that what happens in an assessment, what you can and can't do in an assessment, as opposed to the question of whether and on what terms you get an assessment, isn't really something that's addressed in section 70 or section 71. They're all about whether to grant an assessment and if so, on what terms.
So the purpose there is really no purpose, or maybe no purpose, in section 71(3), because if the executor has by mistake passed these through, that's it.
Is allowed too much, then yes, I accept that. But that is, I mean, of course, it's the open question whether I'm right that section 71(3) works in the same way as section 71(1). But undoubtedly, Lord Justice Lloyd said in respect of subsection 1, that's the consequence, that it is of limited use.
Okay, can I just be sure I've understood this? I think your submission is, once you pay a bill, you're to be treated as accepting that the amount is reasonable. So if the executor pays the bill without querying it, no matter how high it is, the beneficiary is stuck with that. Is that?
Well, you are right to say to me that under section 70, if the executor can show special circumstances, he can have the bill assessed.
So there are circumstances in which, despite the fact you paid the bill,
You can get it
you can
assessed.
still get it assessed. So
I accept that.
So if the executor crosses his desk on a Friday afternoon and actually he just pays it, but on the Monday takes a proper look at it and says, hang on, that's a bit high, he can then challenge the quantum.
He'd have to get over special circumstances, but yes, if he can get over that hurdle, yes.
I'm very reluctant to interrupt, but just to ensure the debate does not go off on a tangent, if he does it within a month, he has an absolute right.
I'm so sorry, that is right. Within a month, I'm sorry.
Even if paid.
No,
Even if paid.
No, my learned friend's right. I apologise. Yes, you get a month from the bill. It's only after. I'm sorry. My learned friend's absolutely right to correct that. He would have a month as of right.
After payment.
Well, no, after delivery of the bill. But the month is as of right, whether or not you pay within that month. I'm sorry, my learned friend's absolutely right to correct all that.
I see.
So you get a month as of right. But if you paid the bill within a month, then at the end of the month you go straight immediately into special circumstances. I'm grateful for that.
I thought your submission was, on the basis of what Lord Justice Lloyd said in Tim Martin, was that once the executor had paid the bill, he had approved the quantum as reasonable, and therefore the beneficiary can't challenge it. But I don't find that difficult to reconcile with the Act saying that if you pay, you can still get an assessment. Either it appears if you apply within a month of payment, you can get an assessment as of right, or within the next 11 months, if you can show some special circumstances. Because on the assessment, if it's open to you to challenge quantum, then the mere fact you've paid the bill can't preclude you from challenging quantum. I don't understand how, therefore, the mere fact the executors paid the bill precludes the beneficiary from challenging quantum. Because what Lord Justice Lloyd says is, beneficiary can't challenge quantum unless the executor could.
Yes.
But the executor can challenge quantum.
As my learned friend reminds me, for a limited period only.
Even after payment.
For a month only, and then he has my learned friend's right to remind
that
me.
means payment is not acceptance that for all time that the charge is reasonable.
Well, it may be that it's acceptance, but something that I would just say I've submitted on the ordinary use of the word payment as acceptance, because you don't pay a bill if you don't agree with it. But that the fact there is acceptance in that sense is not a complete bar to seeking an assessment within a month, as my learned friend reminds us, there's a right. After that, there are special circumstances. But ultimately, that is ultimately all water under the bridge here, because except in respect of one bill,
Yes.
incontrovertibly, it was to that the executor couldn't take any point at all because he had paid more than a year before this claim form was issued.
But 71.3 is concerned with the position of
Yes,
the beneficiary, not the position of the executor.
but to get that's the criteria for granting the assessment. But if you ever got to an assessment, the point could certainly be taken. Well, you can't take this point because the executor paid the bill more than a year ago, and therefore he couldn't.
And as I think you accepted about 20 minutes ago, that would not be determinative of itself. It would be a matter to be considered.
It wouldn't be determinative of the question whether to grant an assessment. If you get to an assessment, the fact that the bill was paid by the executor more than a year ago would be one of the things that is determinative against the beneficiary being able to take the point. Subject. So that's one of the reasons I say that an assessment would have been futile, but that there are other fact-specific reasons that actually, if one looks at the material before the master, there was nothing to suggest that the beneficiary had any chance of getting anything off.
But the cost judge found that there were special circumstances, and that's not the subject of an appeal.
No, that's not. No, we don't have permission to appeal that, and we haven't renewed our application to this court. But the fact there are special circumstances doesn't mean the court must grant an assessment. It means the court may grant an assessment. And my submission on that, which is the final bit of the appeal, is that if there's nothing before the court to suggest, and indeed all the indications that to the contrary, that the beneficiary can achieve anything worthwhile from an assessment, the judge was wrong to grant an assessment. And undoubtedly, in my submission, he was wrong in his approach because he proceeded on an incorrect understanding of what would be open to the beneficiary to say, even if Tim Martin applies, and even leaving aside the issue about the fact that the executor had paid more than a year ago. He identified certain items that I say were ultimately all to do with quantification and precisely the kind of point that on the authority of Tim Martin, a third party can't take.
So where does that leave the finding that, as the judge put it rather obviously, there are special circumstances?
Well, it leaves the gateway can be breached. There is a discretion then to order an assessment, but I say that discretion shouldn't have been exercised because ultimately an assessment would be futile, and it would be. And if we had, incidentally, although this is not a direct answer to your lordship's point, that aside, if there was to be an assessment, and unless I succeed on this appeal, the basis on which the master, even if there was an assessment, would conduct it. I'm saying it is wrong because even if Tim Martin does apply, well, he says two things. One is it doesn't apply, and two, even if it does apply, I can look at points that at some point the executor could have taken, not merely points that are now open to the executor.
If I've read the judgment correctly, one of the principal reasons that the judge found special circumstances was the large discrepancy between the estimate and the actual.
Yes.
So it must follow from your submissions that large discrepancy which the beneficiary is liable to pay is again not a matter that the beneficiary can raise with the solicitors who are responsible for the discrepancy between the estimate and the actual.
I mean, it is important, just on the facts, that the estimate, and we can have a look at it, was given in very qualified terms. The executor hasn't disputed that. He hasn't disputed the bills as being in excess of the estimate. He hasn't disputed them on that basis. We've got all the bills. Most of them he approves expressly, and even the few that he doesn't approve expressly, he signs off on the estate accounts that have all but the last two bills in them, and he's paid all the bills, as you've heard me say, all but the last one more than a year ago. So I would, of course, say advisedly, but whether your lordship takes the view advisedly or inadvisedly, the executor hasn't made that complaint. It's also, that's my first point, The second point is it's important to understand what the complaint against the solicitor is in these estimates cases. It's not that the solicitor is overcharged, because you don't need to worry about an estimate to say you've spent too much time, etc. It's that the solicitor's underestimated and failed to correct it. So often the premise of these estimate cases is if the solicitor had given an accurate estimate, everything they charge would be fine, because if that weren't the case, you don't need an estimate just to say there's overcharging. But and this leads on to the complaint in an estimate case is not overcharging, it's underestimating and typically not correcting it when it became apparent that the estimate was an underestimate. But the third point is, although the authorities, and I can go to an authority in the bundle called Eversheds, although when a client takes an estimate's point, it's not enough just for the client to say, you went way over the estimate. If the solicitor leaving the estimate aside can justify its costs, the client has to show some degree of reliance on the estimate. Otherwise, and often, perhaps unusually in Solicitors Act assessments, when an estimate point is taken, generally speaking, and Harrison is a case that I was in, and this is what happened, there's actually cross-examination of the client, because the client is saying, well, if you told me that fees were going to be 3 times your estimate, I would have settled and not fought. By that point, the solicitor's saying, oh, come off it, you were going to fight this litigation tooth and nail, whatever the costs were. There was no reliance. And reliance isn't something that can be decided on the document. So there's often live evidence and cross-examination on the issue of whether there was any degree of reliance by the client. So in order to get an estimate point off the ground here, the beneficiary would have to have the executor coming along and saying, I relied on these estimates and I would have done something differently if I'd been given a larger estimate. Now, we all know on the facts that isn't going to happen, and it was never suggested. So even if that point, and I say it's not open to the beneficiary because it's par excellence a quantum point, but even if that point was available, the beneficiary could not possibly get anywhere on an estimate point because he won't have the evidence from the client that the client relied on the estimate.
Yeah, so that's quite a long answer.
I'm sorry, my lord.
But I think the answer to my question is, I think the answer to my question is yes. That's not a point for whatever reason, whether it's the facts, whether it's the practical difficulties, whether it's section 71(3), as you say, interpreted by Tim Martin. The answer is yes, that ends up not being a point open to the person ultimately responsible for paying the bill.
Yes, that's there. Can I just show you, if your lordships are happy for me just to move on to the rules that Lord Justice Lloyd mentioned. They're actually now in rule 46.9.3, not 48.9.2, and it's page 1512 of the first volume of the White Book. I'm afraid I don't think we've put these in the authorities bundle.
Just as a word of advice from now on, it's not your fault now, but we are now not provided with a white book that's up to date.
Oh my lord.
We all have them in our rooms, but we don't always bring them to court. So if you give us the rule number, we'll find it, because I don't think it's changed since the 2022 edition.
It's rule 46.9.
Thank you. Just in case it's not obvious, that's not a change with which I personally agree.
My lord, it was obvious.
46.9.
46.9.
Basis of detailed assessment of solicitor and client costs. Yes.
And
These
it's
are
really
the assumptions.
This is the presumptions at sub rule 3. And A and B, it's really C that I'm going to primarily, but also A and B. Just A and B are presumptions, and my learned friend I think will show the court authority that says informed, the approval of the client in the context of this sub-rule means informed approval, and I accept that. But I say the cases on this are not the same as whether the cases are not cases on whether the payment of a bill amounts to approval. But what these presumptions in A and B do is they create a presumption that costs are reasonable. In other words, if the client has given informed approval to costs, the solicitor doesn't have to prove they're reasonable. It's a presumption. So it's a very specific thing. It's a presumption that something is reasonable and the solicitor isn't expected to prove it, unless, and it's fair to say that it's a rebuttable presumption, but it's a difficult one to rebut. And the classic case, whereas if a client agrees to hourly rates, it's not impossible, but it's extremely unlikely that they will be reduced on a solicitor-client assessment because the clients agree to them. And then I come to sub-rule 3, which, subject to a qualification I want to make, can be seen as a codification of the special arrangements that Lord Justice Lloyd referred to. And indeed, in paragraph 83, I think it was, he referred to the predecessor of this rule. To be clear, it's exactly the same rule. It's just as I'm sure I know your lordship knows that in 2013, the cost rules were reorganised and to a significant extent, it's exactly the same rule, but it's just in a different place. And sub-rule C is the one that Lord Justice Lloyd referred to when he was talking about special arrangements, to have been unreasonably incurred if they are of an unusual nature or amount. And I just want to pick up on the fact this rule says amount, and the solicitor didn't tell the client that as a result the cost might not be recovered from the other party. The first point about that rule is that it travels more broadly than the issue of a third party being liable to pay a solicitor's bill. And in fact, that where that rule is most often relied on is where it is in contentious business, where the client is saying to the solicitor, and the other party means the other party in the litigation in that context. And the most usual way in which this rule is invoked is where the client is saying to the solicitor, you didn't warn me that these costs were unusual and therefore I couldn't recover them inter partes in a contentious matter. Now, Lord Justice Lloyd says that he takes the other party also to be capable of meaning what he calls the third party. And I think something is made of the fact that this rule says not merely unusual nature, but unusual nature or amount. And so that's why I make the point that this rule is much broader in its application than the situation we are looking at. And it cannot be, in my submission, read as countermanding the substantive law, which is Tim Martin. So in this particular case, notwithstanding that this rule would authorise the challenge of an unusual amount, on the basis of the principles in Tim Martin, if I'm right about them, it's only costs of an unusual nature that can be challenged. Because in my submission, Lord Justice Lloyd clearly says in Tim Martin, you can challenge an item as a whole, but you can't challenge its amount under the special arrangements concept.
Can you just give us the paragraph number for that?
It's 83 and 95.
Thank you.
This is all concerned with assessment on an indemnity basis.
Yes, as solicitor client always is. Well,
So the other party must be the other party in the litigation.
yes, that's what I mean, that's how I have always read this rule, but it is right to say that when Lord Justice Lloyd talks about special arrangements, in I think it's paragraph 83, he does refer to the predecessor to this rule. But yes, I've always understood it to be essentially referring to inter partes. But I wanted to deal with that because let me just, I think it's paragraph 83.
Subject to paragraph 2, costs are to be
Sorry,
assessed
95.
on the indemnity basis, but are to be presumed A, B, and C.
Yes.
I mean,
That's the
my
Solicitor
experience
Client.
of Solicitors Act cases is much more limited than both of you, but whenever I've looked at this rule, it's be concerned with indemnity costs orders and applications and disputes.
Well, this rule is to do with a solicitor client assessment, not an inter partes assessment. But the sub-rule C, where it talks about costs that are unusual and therefore not recoverable from the other party, I'm entirely with your lordship that is you're always engaged in a situation where the client is saying to his solicitor, you can't charge me this because you didn't warn me that I couldn't get it back into parties.
But costs are to be assessed on the indemnity basis.
Yes.
When you have an assessment on an indemnity basis, that's one party in the litigation paying the other party in the litigation's costs on an indemnity basis.
It's also a solicitor client costs are also assessed on the indemnity basis.
Okay.
This rule is this isn't a rule about inter partes recovery. It's a rule about solicitor client recovery.
Okay.
46.9, what basis of detailed assessment or solicitor and client
Yes,
costs?
yes.
So it's entirely general.
It's entirely general.
Okay.
But what I'm saying is that sub-rule 3, when it talks about couldn't be recovered, the client couldn't be recovered from the other party. Although this is a criteria for solicitor client assessment, the issue that sub-rule C is grappling with is whether or not the client was warned. These costs are unusual,
Yeah.
and therefore you won't, even if you win, you won't get them back from the other side.
You're having your gown tugged.
From the other party.
But I do say that.
What do you do? Just cross it out.
Yep.
So, my Lord, I just want to knock on the head the point that this rule refers to unusual nature or amount. If I'm right about Tim Lloyd and what it says,
Well, it does refer to unusual nature
yes,
or amount.
but I say that doesn't drive a coach and horses through the restrictions in Tim Lloyd, because it's dealing with matters generally, and the if I'm right that Tim Lloyd holds that it's just nature.
Tim Martin.
Tim Martin.
Lord Justice
Lord,
Lloyd,
I'm so
we
sorry.
understand we've made that same mistake.
Justice Lloyd, I didn't mean that. I apologise for the discourtesy.
No, that's fine. So you say this doesn't drive a coach and horses through Tim Martin.
Where Lord Justice Lloyd says you can only challenge items as a whole as being outside the beneficiary's liability. You can't challenge amounts.
Well, he says you can't challenge amounts unless the executor.
Unless the executor could.
Couldn't the executor challenge amounts under 46.9 on the basis that they were of an unusual amount? And you should have told me and you didn't.
Well, it might have been this. I think this comes back, I think, to the fact that payment makes a difference and whether there's a temporal element to this. It might be in some cases that at some point the executor could have done that, but there comes a point where the executor can no longer do that, even if it was once open to him to do so.
So that wouldn't be a question of a coach and horses through Tim Martin, even if you're right. It just means nature or amount depending on the facts. Because if the bill had been challenged within the month, then blah, blah, blah.
Yes.
You can challenge the amount.
But if the executor hasn't, yes, it turns on the facts.
Yeah. Yeah.
My Lords, I'm now going to turn to the cost judge's judgment, and the focus of the appeal is it's tab 5, beginning at page 86. That's not the beginning of the judgment. That's the beginning of my focus for this appeal.
You say 86.
Page 86.
Thank you.
And it's dealt with under the heading B3. In the light of the decision in Tim Martin, would an assessment serve any useful purpose? Actually, the answer to that on the facts comes later in the judgment. The first issue with which the cost judge grapples with in this section of his judgment is how Tim Martin works, if I can put it like that. And I've made my submission that there can't be a difference here between sections 71 and 73. This isn't a question of whether Tim Martin applies, it's a question of what it does when it does apply. And I was going to deal with this first of all because that's the order that the cost judge dealt with it in. And his suggestion, I've made my submission on this, that his suggestion that he makes at paragraph 70, which is on page 87, and also at paragraph 76 on the next page, page 88, that at any point that the executor could have taken, or of a type that's open to the person charged with the bill, I do so as a direct attack on the ratio of Tim Martin where it applies, because Tim Martin does say that a third party can't hark back to points that at one stage the client might have taken but can't anymore. And I've made my submission that if Tim Martin is understood that way, then everything that Lord Justice Lloyd said begins to unravel. I did just want to deal in respect of paragraph 70 with the case that the cost judge referred to of Brearley and Shepherd. Now, I did yesterday, and I hope it hasn't caused too much inconvenience, we did hand up an additional bundle of 4 authorities.
Yeah, speaking for myself, I've not had time to look at
No,
them.
understandably not, my lord. They weren't in the agreed bundle, but they, at one level or another, they are all referred to in the judgment. So, Shepherd and Cohen Brearley. This is a case, although of course it doesn't bind your lordships, I did want to show it to you, where a different cost judge reaches the opposite conclusion to cost judge Brown and holds that subsection 3 works in the same way as subsection 1. And that is at tab 4 of the additional authorities bundle. And it's pages 8. I want to go in particular to paragraph 84. Sorry, page 84, forgive me. And paragraph 24.
Paragraph
24. 24, bottom of page 84. And this is a different cost judge Rowley says that section 71 is mimicking the provisions of section 70. Subsection 1 sets that and then he's referring to subsection 1 sets out the right to challenge the bill as if the third party were the client. Subsection 3 echoes section 72, where if the challenge has not been brought sufficiently promptly to be made as of right, the court can order a detailed assessment on such terms as it sees fit. The order is invariably made in such circumstances, but often made with the payment on account of the outstanding fees. The phrase "the court may on such terms, if any, as it thinks fit, order a detailed assessment" in section 72 is identical to the terminology in section 71(3). It might be thought that the month for bringing the assessment as of right to a bill that was approved by the trustee would often have passed before the beneficiary even saw the invoices. In such circumstances, appropriating the words used in section 72 rather than section 71 might well have seemed a pragmatic approach. So that comes back to my Lord Justice Stuart-Smith's point that the factors that absolutely bind under subsection 1 are merely to be taken into account under subsection 3. Section 71 continues to mimic section 70 and other provisions. And then at paragraph 26, he says, assuming this analysis is correct, the terms on which the detailed assessment would be assessed relate to matters such as the interim payment, rather than whether the all or nothing approach to the items claimed should be followed. On that basis, there is no difference between section 71(1) and section 71(3) in terms of the assessment. And then he says at 27, drawing these 2 points together, I consider that the dicta, I have to face the fact he says dicta rather than ratio, of the Court of Appeal judgment were plainly intended to deal with all section 71 cases. Furthermore, the difference in wording between subparagraphs 1 and 3 can be explained as a reflection of section 70, rather than as intending to provide additional latitude to the judge who assessed costs in a section 71(3) case. As such, the phrase entitling the courts to assess the costs on such terms as it thinks fit relates to matters such as a payment on account as the price for an assessment, rather than the manner of the assessment itself. Well, that may be seen as putting rather better the point I've endeavoured to make. Of course, it's a first instance decision, doesn't bind your lordships, but I show it to your lordships, and for what it's worth, there's obviously a difference of opinion amongst the cost judges. The other reason, I won't go to this now in the interest of completing in a proportionate amount of time. Cost Judge Brown says that this point wasn't appealed, I should say. So, Mr. Justice,
I was going to say, so Mr. Justice Kavanagh's judgment doesn't deal with it.
Doesn't deal with it. The only reason I put that in, and perhaps given the hour, I'll see if my learned friend makes anything of it, is that the Cost Judge Brown says in the judgment under consideration today that what Mr. Justice Kavanagh said supports his approach, that you're looking at the type of point that the client could have taken. My submission, I won't go to it. My submission is that Mr. Justice Kavanagh doesn't lend any support to that approach. But I'll.
But if the point didn't arise, your principal submission is the point didn't arise, so we don't need to.
The point I've just addressed didn't arise, but Cost Judge Brown also refers to the appeal decision as saying it supports his approach, that you look at the type of point, not the that the executor could have taken. I just say it doesn't deal with that at all. The other authority I need to go to, because, and this is no criticism of anyone, there's a case, and I'm probably going to pronounce it wrongly, called Menzies, which both my learned friend Skeleton and the cost judge refer to on the concept of what is payment. And it's nobody's fault that since the cost judge's judgment and the Skeletons, the High Court decision which has been referred to has been overturned by this court on precisely that point. So what the High Court said, and it's tab 1 of this authorities bundle, at page 14, they were looking at what payment under the Act meant, under the Solicitors Act, one of which of course pressed me on already. In particular, paragraph 40 onwards on page 14. So this is the judgment that has now been appealed.
Sorry, paragraph
40, 40.
of the first instance.
Of the first, I'm so sorry, forgive me, I'm so sorry. I'm doing this in the wrong order. It's tab, I'm so sorry, I do apologise. It's paragraph, it's,
Tab 1 is the first instance, and then
First
tab
instance.
2 is the very recent.
yes, I'm sorry, I'm almost right, it's 39 to 41 on page 14.
Page 32. Page 32.
It's page 14 of the Supplementary Authorities bundle. And it's paragraphs 39 to 41, which have been sidelined. And it's referring to a letter that the solicitor has sent the client expressing the position as to how the costs can be challenged under the Solicitors Act. And 39 says that paragraph didn't clearly identify that the appellant had a choice between 1, declining to agree the deduction, in which case the respondent might apply for its own bill to be assessed, and 2, agreeing the deduction, in which case the appellant could still apply for an assessment of the bill if he wished. On the contrary, the letter introduced various other matters, and I won't read that in full, but were unsatisfactory. And then at 41, on the facts of this case, I therefore conclude that the respondent did not inform the appellant with sufficient clarity that he could object to the deductions within a reasonable time, failing which it would be taken as agreed subject to his statutory assessment rights. In those circumstances, I have concluded that the payment, that's the payment of the bill, was not affected by a settlement of account. And that's the very point that the Court of Appeal overturned this on. And I'm sorry for getting myself in such a muddle. That's tab 2, and it's page 33, but it's also paragraph 40. So in fact, I should start at page 32. And under the heading discussion, the only question on this appeal is what is required by section 74 to constitute a payment and whether those conditions have been satisfied. And in paragraph 41, what the Court of Appeal says is that at the end of that paragraph, payment for the purpose of section 70 is a transfer of money or its equivalent is satisfaction of a bill with the knowledge and consent of the payer.
Where are you, sorry?
Bottom of paragraph 41 on page 33. And then at paragraph 42, 3 lines down, the delivery of a compliant bill, and the bills have been held to be compliant here, will give the client the necessary knowledge. The requirement of consent does not, in our view, require that consent be given after delivery of the bill. If the client has already validly authorised the solicitor to recoup his fees by deduction, that was dealing with something with the retainer in that case, from funds in his hands. What the client needs to consent to in order for payment to take place is the transfer of money, not necessarily the precise amount.
Well, all doubtless gripping. I'm sure it's entirely my fault, but I'm struggling to see where this goes in our case.
No, my lord, it is a subsidiary issue, but the master cast some doubt in his judgment about whether there had been payment within the meaning of the statute, but he was relying on a High Court decision that basically said you needed something more than just the consensual transfer of money. And the Court of Appeal reversed that and said, no, the consensual transfer of money is enough. And I'm sorry, I should also have shown your lordships.
But that's not part of the appeal, is it?
No, it is. Sorry if it's a distraction, but
This appeal.
no. Well, it might bear on my Lord Justice Nugee's point about whether the client could still have taken the point, because the problem with the client taking the point, or the limit on the client taking the point, is if the bill is paid, then the clock is running out very fast against the client. But what the complication this introduced is that the transfer of money might not be payment within the meaning of the statute on the High Court decision. But the Court of Appeal, if I can put it colloquially, knocked that on the head and said the transfer of money is payment under the Act.
If the client has already validly authorised the solicitor
Yes.
to recoup his fees. Well, that's quite a big if, isn't it?
Well, there's no
The mere transfer of funds is not sufficient. It's sufficient if the client has already validly authorised the solicitor to recoup his fees by deduction from funds in his hands.
That's dealing with the point where the client gives consent before the delivery of a bill. So if the client, even that would do for payment. If the client in the retainer says you can deduct my bills from your account, then that is consent, which makes the payment a payment, even if the client doesn't give any separate approval.
I'm sorry, I'm obviously missing the point. You
sorry.
took us to the last 3 lines of paragraph 1.
Yes.
Payment, they've adopted Lord Justice Aldous' description in Goff. That payment for the is a transfer of money or it's in satisfaction with the knowledge and consent of the payer.
Yes, that means knowledge and consent to the payment. That's enough for it to be a payment of the bill. And maybe it doesn't import a requirement that there has to be a conscious approval of the items in the bill. It's enough that the payment is, if the payment's consented to in that way, then it's a payment under the Act.
Okay. Even though but although it doesn't condescend to the detail of individual items.
Well, that's what's being said here. On the facts here, the bills did condescend. But that's what's being said there. Yes.
No, but the consent doesn't. The consent doesn't have to condescend to individual items.
The consent only has to condescend to the consent to payment, and then it's a payment. So, my lord, that's all I've got. I've really said all I've got to say about whether it's a point that's still open to the client or a point that might once have been open. And that, when I get to the last bit of my submissions, is the problem with the way the judge looks at whether the beneficiary had any credible challenges. That he because he's misunderstood Tim Martin, he thinks the beneficiary, in my submission, could take various points that clearly I say the beneficiary couldn't. The next question, although it might not be the next sorry, I don't mean that's discussive. The judge, the next in the order he dealt with them was, does Tim Martin apply to section 71, subsection 3? And he deals with that in his judgment starting at page 89 and paragraph 79. I've made most of my submissions on this already while we were going through Tim Martin. So I just need to deal with a few points to essentially to mop them up that I didn't deal with. The judge makes reference on page 90, paragraph 83, to it being a significant distinction here, that unlike the situation under subsection 1, under subsection 3, the client owes fiduciary duties to the third party. And I simply say that is irrelevant to the solicitor's position, whether there's a fiduciary duty between the client and the third party.
Which paragraph are you talking about?
It's paragraph 83.
Thank you. I've written down 93, which is why I was...
It's at the very end of that paragraph on page 90. In the case of a subsection 3 application, the executor owes fiduciary duties to the beneficiaries. this seems to me to be a distinction of substance. My submission is it makes no difference as between solicitor and client. It might make a very significant difference as between client and third party. But if I need to say more on that, I would say this with reference to subsection 1, although it's not necessarily the case under subsection 1, and may often not be, that the client owes a fiduciary duty to the third party. You can conceive of situations that would fall in subsection 1 where there was a fiduciary duty. And if the cost judge was right to make this as a distinction between subsections 1 and 3, it would also apply to subsection 1 where there was a fiduciary duty. So it cannot, in my submission, matter. And then I've made your lordship pressed me on whether I accepted it was obit and I didn't. So I do say where the judge, to be fair, the judge frankly acknowledges that he's departing from what Tim Martin appeared to say, whether obit or otherwise. And I've made my submission that it was actually ratio. But if I just want to go to paragraph 94 at page 92, because I say this illustrates the error into which the judge below fell, because he cites as an example of something that he says can be done under subsection 3, an adjustment to hourly rates. So at paragraph 94, page 92, he says the bank and Tim Martin would hardly complain that the solicitors have charged City of London rates, having chosen to instruct the firm in this area, in circumstances where the bank might have be assumed to be aware that they would not recover those rates in county court litigation against the borrower. But as appears from Ray Brown, in my submission it doesn't, a trustee who for their own personal convenience instructs City of London solicitors at high rates would appear to have difficulty charging the additional sums associated with such an instruction to the estate. And importantly, it seems to me that that is the case, whether it is the trustee who applies for an assessment or a beneficiary. Firstly, I say I don't see that one gets that from Ray Brown, and your lordships have seen it, so no doubt your lordships will form a view, have seen Ray Brown, and no doubt your lordships will form a view on that. But in any event, this reveals the error. If the trustee goes to a city firm, the city firm is going to charge city rates, as it can be fully expected to do, and the trustee presumably will take those rates from the estate. And if the beneficiary has a complaint, it's not against the city firm for charging city rates, it's a complaint against the trustee for using the city firm.
Well, that's back to the point.
And it should take it from the trustee.
Back to the point you made this morning.
Yes, my lord.
I mean, we take the point that you say that doesn't come from Ray Brown anyway.
No, it doesn't, in my submission.
Yeah.
And then I've already made my points that if there are limits to the taking of an account, that's not something to plug with the Solicitors Act, that's just where the law has ended up on the relationship between trustees and beneficiaries. But I do just draw attention on page 194 to paragraph 106, where the judge says this. It is not clear whether the court in Tim Martin was addressing any detail on the issue as to whether an account might be available to a beneficiary in the same way that an account is available to a mortgagor. And the suggestion there is that maybe what was said in respect of the right thing to do under subsection 1 is seek an account that might not work under subsection 3. I mean, I have just 3 short answers to that. The first is that observation cannot, in my submission, be relevant to the approach under the Solicitors Act. The second is that, of course, a beneficiary, in principle, does have the remedy of an account available. And the third, and with all respect, when it said it's not clear whether the court in Tim Martin was addressed, if I get the name right, we can safely assume that Lord Justice Lloyd knew very well what remedies a beneficiary would have, an aggrieved beneficiary would have against the trustee. That's really all I've got to say, because I dealt with the bulk of my submissions about whether Tim Martin applies when we were going through Tim Martin. So the final section, I can deal with this fairly quickly, is could there be a meaningful assessment in this case if Tim Martin is applied in the way that I submit, it ought to be applied. As I say, the difficulty with any submission that, well, the judge dealt with this in the alternative, is he dealt with it in my submission on a wrong understanding of how Tim Martin worked when it did apply. And it's pages 98 to 99 of the bundle. It's about 7 paragraphs between 121 and 128. And it's here that he's suggesting points that really might be open to the beneficiary. And I say actually on inspection, it confirms the opposite. So can I go to paragraph 122?
Is this broadly speaking, I mean, there may be particular examples, but is this broadly speaking what I have called the type point?
Well, actually,
That it's the type of point, and you say no, that's too wide. It's what point they could have taken, and if the bill had been paid, then it's very restricted, and so on.
it's actually more, and it's more that he is saying that just sort of quantum points can be taken by the beneficiary. So in 122,
Because they're the type of point that could have been taken by the client if
some point.
challenged. Yes.
So he gives 2 examples. One is that there was a bit of work pre-retainer. Well, I don't think I need to go to it, but there's an implied obligation, even if the retainer hasn't been signed, unless everyone's contemplating a CFA or something like that. That wasn't obviously the case for the administration of the state. There's an implied obligation to pay for solicitor a reasonable amount for work done. Secondly, he says he's identified some points in the bills already.
Where are you?
Sorry, it's paragraph 122. I'm so sorry, my lord. And about 4 lines from the bottom of that paragraph, he says, I have identified some costs that may possibly be caught by this objection, but I cannot exclude the possibility there may be more. As I read it, although it's not expressly cross-referenced, because he doesn't identify them in this paragraph at all, I think so. I understand him to be referring back to a discussion of the invoices, and if I could ask your lordships to jump back at paragraph 48 on page 82. So I think this must be what he's referring to, because it's the only place where he identifies potential criticism of the invoices that I have seen. So he says he gives examples only of matters that give rise to possible concerns. So respectfully, it's all fairly tentative. And then under the invoice of the 17th of October, charge for funding work, file opening and quoting for work. And in fact, I can go to it if it needs to be. That all depends, as we say in our skeleton, on what the retainer authorises. And this retainer specifically authorises the solicitor to charge for its own work in opening the file.
We're getting into the detail.
We are.
That you say, as a matter of principle, we shouldn't.
That's right.
And I don't think you can, this time at any rate, have your cake and eat it. Your case is, you can't look at these accounts at all. You can't look at these bills, I'm sorry, at all. Because it would all be useless, because you have no rights, because they've all been paid except 1 or 2.
Yes.
I'm slightly concerned that we look at the detail and you say, well, this can't be right and it's under the retainer. We're doing exactly what you say we can't do.
Well, yes,
It's not a black and white point, this. Either you're right or you're wrong. If you're wrong, then on Tim Martin, then why should there not be an assessment?
If I'm wrong on both, well, I suppose I only have to be wrong on, do I have to be wrong on both or only one? If I'm wrong on both, if I'm wrong on either of my points, 1 as to whether it applies and 2 as to how it applies, so if it doesn't apply at all, or it applies in the way I say it applies, not the way the judge said it applies, if I'm wrong on either of those points, yes, I accept that you know, I can't pursue the point. I'm going to this to deal with the point, and maybe the life of your lordship's indication, I will short circuit.
Well, that's just speaking for myself. It's a bit like saying there's no reasonable cause of action, and then looking at the detail to say, well, you know, on one view there might be a cause of action, but actually we've got an answer to it, and it becomes You move away from the straight and narrow.
My Lord, yes, the reason I feel compelled to do something on this is because the cost judge does have a section in his judgment that effectively says, even if Tim Martin applies, there are some worthwhile points open
Yes.
to the beneficiaries. And I suppose really what I've made my point that he's wrong on how it applies, even if it does. And I suppose all I'm doing now is taking your lordship to the examples he used to show that if I'm right on my submission on Tim Martin, these are the kinds of points that can't be taken. But I can leave, but your lordship is basically right.
No, carry on making those points. I don't want to stop you.
If one looks at these, so if one looks at the examples he gives, they're none of them the kind of points which Tim Martin says can be taken by a third party. Extensive involvement by a senior fee earner on the second bill, the January bill, hours by a junior fee earner on telephoning, then there's, I don't need to read them all that, they're essentially all, these items look a bit high. And those are par excellence, if I'm right about how Tim Martin works, the kind of points that can't be taken. There's nothing to suggest that they're nothing to do with the estate or that they are special
These are paragraphs
arrangements.
which?
I'm so sorry, my lord.
These are paragraphs which?
It's all paragraph 48. He just goes through the bills and basically ticks off some time queries.
But those are examples of some of the points he's been making in previous paragraphs. This is all quite a lengthy section, isn't it? Starting at 38.
Yes.
And this is all designed to say there are special circumstances which you're not appealing.
Which I'm not appealing. But the reason I go to this is because I had read the judgment in the bit I am appealing as referring back to this. So perhaps I'll go back to the bit I am appealing. Perhaps that would be more. I'll do myself better. Do myself more favours by doing that.
Well, I'm just trying to referee this.
No. Well, let me go back to the bit I am appealing, which is at page 98. I don't think I need to go to that more. It's because he says, the judge says at the end of paragraph 122, I've identified some costs that may possibly be caught by this objection, but I can't exclude the possibility there may be more. So I simply went back, because that's what I think he's referring back to, because in this section he doesn't identify anything, and I don't think that will be disputed. That actually the things he identifies are points which on my submission a beneficiary couldn't raise.
They're quantum rather than quotiers.
Yes, exactly,
in
my lord.
Brown language.
And then
I'll make a note.
at a paragraphs 123 onwards, and this is why I perhaps belaboured a little the point about why Rule 4693C. I think he's wrong to say 3B at paragraph 1, 2, 3. I think he must mean 3C, because that's the 3C is the one that talks about unusual nature or amount. This is why I laboured the point that even though that rule talked about unusual nature or amount, on the authority of Tim Martin, in this particular context, it can only be nature, not amount, that a beneficiary can challenge. And I won't go through all that again. But he seizes on the word of that rule. And then the rest of this is things like hourly rates, etc., that are all to do with amounts. 123 to 125, he illustrates the point by saying that perhaps the hourly rates are too high. As we say in our skeleton, they're not, but that's exactly the kind of point that isn't available to a beneficiary. So I don't need to spend any more time on that. They're all points that are on my submission on Tim Martin, simply not available at this point to a beneficiary.
And that's one paragraphs 123 to 128.
That's 123 to 125. And then the rest of that, sorry, I put that away too quickly. I'm so sorry, my lord.
Okay.
124 and 125 are his giving, he's saying, having, again, he talks 124 about unusual in amount or nature. And I say that's a mistake. But what he gives us as example on at 125 is hourly rates. Which are obviously an amount, not a nature point. And then 126, he goes on to say, if the claimant can take any point that could have been taken by the executor, and I've made my submissions on that type of point versus points that the executor can now actually take. So there's nothing that the beneficiary identified that they could plausibly, with any worthwhile effect or meaningful effect, raise as a challenge to these invoices, and if they have a grievance, it's an grievance against the trustee. But I do just want, finally, the court, I won't go through all these, the court has in the supplementary bundle all the invoices, they're particularised. In respect of most of them, there's an email back from the executor saying, yes, fine, please pay. And in respect of all but the last two, they're signed off on the accounts. And I did just want to show the court when the invoices were paid, and there's a helpful table in the supplementary bundle at tab 22, page 113. And just those are the bills. I don't think there's any dispute that there's any. I don't think the accuracy of this is challenged. So this claim form was issued on the 25th.
Sorry,
of
page
113 of the supplementary bundle.
Yeah.
So that the claim form, I don't think we need to turn it up, and this claim was issued on the 25th of April 2022. And so your lordship sees from this that all but the last bill were paid more than a year before that. The penultimate date is the 23rd of March 21, and the final bill was paid on the 2nd of April. So they were all paid. If your lordships want them, the invoices themselves are in the previous tabs. And there was a set of accounts, and your lordships have that at tab 37, beginning at page, I'll come back to 157, which is important, but the final accounts are at page 158. And they include all the invoices of the solicitor, except, just to be clear about this, except the last two that post-dated these accounts. And although we don't actually have a copy with the executor's signature on it, there was evidence before the cost judge that was not traversed that the executor, Mr. Bieber, approved these accounts on the 9th of March 2021. That's page 5 of this bundle if your lordships want it. And just finally a point on the facts, although we didn't need to, we did actually send these accounts to the complainant, the claimant beneficiary who now brings this claim for an assessment. And I did just want to show your lordships that. So we sent him these accounts on the 8th of April 2021, and that's tab 32, page 139. And this is an email to the claimant, not to the executor. So they were sent to him in April 21. I don't think you need to go to the accounts. But then on page 153, so that's just the next tab, we sent them to, we chased him on the 25th of June for approval. The next tab, page 154, he said he would revert by the 2nd week of July. This is still all 2021. And then on the 1st of July, page 155, we got, I won't read it out, what I would describe as a somewhat intemperate email back from the beneficiary. And then on 156, 27th of July 2021, we said, as we haven't had a response, we're going to conduct the final distributions. My Lord, may I just turn my back for a moment? My Lords, unless there's anything else, I can assist the court with those.
Of course, by the time of those exchanges in the summer of 2021, all of the large sums in the account are well beyond the month cut-off,
Yes.
and most of them are beyond the year cut-off.
Yeah, my Lord, yes, yes, I said that.
No,
Yes, sorry, my Lord, my learned, I'm trying not to go too deeply in the facts. My learned junior rightly reminds me that there was actually an earlier. Is that to him? Oh, sorry. Sent to in 5th of August 2020. The claimant's solicitors were sent an earlier version of the accounts on the 5th of August 2020 at page 125, tab 31. That's just by way of factual context. My Lord, unless I can assist further, those are my submissions.
Mr. Marvin, thank you very much. And before you sit down, we should say we're aware that you came into this case late, and all we can say is that you wouldn't be aware of that if you didn't already know it, because
My Lord, that's very kind of you.
It doesn't appear to us that there's been anything on which you haven't made very clear submissions. So thank you very much. Yes, Mr. Mallory, would you like to clear some decks before the short adjournment?
My Lord, I'll endeavour to do so with one short point and one point which may be a little longer. Whether I'll get through it before the short adjournment, we will have to see. The first point is just to address the final point, the factual point my learned friend Mr. Marvin was making. The short point in response to that is that, of course, it is no part of this appeal to suggest that the learned cost judge was wrong in allowing the assessment to proceed because of any delay by the beneficiary in bringing the application.
Yeah.
So that's not said, and therefore, whilst it's instructive to go to, and if necessary, I can go to the parts of the correspondence which illustrate the beneficiary raising issues with the bills at an earlier stage. But none of that really is going to assist this court because that is not an issue on this appeal. It was accepted below, and just for your lordship's reference, I don't invite you to turn it up, that the court had a discretion to allow an assessment despite the fact that some of these bills had been paid by the executor more than 12 months before the time of the application. It was accepted by the appellant below that the cost judge still had discretion, and there is no appeal against his exercise of that discretion in that regard. Just for your lordship's reference, that is paragraph 22 of the judgment, page 77 of the main bundle. In the few minutes remaining, may I, if not completely deal with, at least tee up a point which may be of some relevance to this appeal, because of my learned friend's focus on this question of payment and what its relevance is said to be. And I'll try and make the headline point shortly. It may be that having made the headline points, I may not need to develop them further, but if I can try and at least make the headline points in a few minutes and develop them if I need to in due course. it is important to understand the relevance of payment in the context of solicitor-client assessments. Payment is a potentially procedural bar to the court ordering the assessment. And the Lords, we will see that we will come back in due course inevitably to section 70 and section 71. But your Lordships have seen that already, and indeed, as the Lord Justice Stuart-Smith put it, the net effect of that in the context of a beneficiary is even if the executor client himself would have been time barred for bringing his proceedings for an assessment under section 70 subsection 4, that time bar does not prevent the beneficiary bringing a claim for an assessment, but is a matter for the court to consider as part of the question of whether to grant that assessment. To use the Lordship's wording, it is not a showstopper. Once an assessment has been ordered, the question then is, what is the continuing relevance of the fact that the bills have been paid? And in my respectful submission, the continuing relevance is no more than this: that once an assessment has been ordered, and I'll stick for a moment with the straightforward solicitor-client assessment, a solicitor may have a defence in whole or part to the challenges made to his bill on the basis that the client has approved the costs which are being challenged. And Lord, we can come if necessary that there's an authority in the bundle which may assist in terms of quite how that process goes. But in short, what would happen on the assessment is that the client would identify objections to the bill by way of what are called points of dispute. The solicitor, in replies to that points of dispute, may say, well, you can't pursue that point because that item of cost, or indeed all of the costs, if it be the case, were approved by you. And as Mr. Melvin accepted in his submissions earlier, that approval would have to be an informed approval, not a mere rubber stamp. And where is payment relevant? Well, payment may be said at that situation to be an indicator of approval. If you have paid something, it may be said that the fact of the payment indicates that you were approving. But that is by no means conclusive. Payment may be an indicator, but once we're on the assessment, once we're past the procedural bars in section 70 and subsection 71, the issue which will be the heart of the defence is not whether there was payment, but whether there was approval. And that, my lord, is what we saw in CPR 46.9, where it indicates the presumptions that apply in circumstances where the client has approved items of costs. So the solicitor's defence is, you challenge these items, but you approve them. That gives rise to a presumption. It's for you to rebut the presumption, and if you can't, those costs cannot be challenged. And my lord, just to illustrate one final point in relation to this, my learned friend took you in his supplemental authorities bundle to the Court of Appeal's decision in a case called Menzies, or I think some say Mingies if he's Scottish, I know not which, Menzies and Oakwood. And my lord, it's tab 2 of the supplemental authorities bundle.
Nobody ever said I'm going down to John Mingy's.
Lord,
They weren't the party.
Lord, I only say it because I was upbraided by a cost judge the other day for describing it as Menzies when he indicated it should be Mingies. So I'm exercising a degree of caution to try and cover my bases.
Quite right. Supplementary
So supplementary bundle,
Tab 2.
and
Yeah.
it's the Menzies and
Yeah.
Oakwood solicitors case.
Yeah.
I just note in passing for your lordship's reference, should it be material, I'm not sure it is, that case is presently subject of an application for permission to appeal to the Supreme Court. I simply note that in passing. But if I can take you to page 33 of that bundle,
Yeah.
you were taken to paragraph 42, and just to very briefly re-encapsulate what the issue was in Menzies, this was to do with the procedural bar. And the question was whether for the procedural bar to operate on the basis that there had been payment which under section 70 shut the client out from an assessment, the payment had to be a settlement of account rather than mere payment. And the court said it didn't have to be settlement account, it had to be mere payment provided that the solicitor was entitled under the retainer to take that payment. So that dealt with the payment point. But can I just highlight what the court said at paragraph 44 on page 33, which is that it must not be forgotten that even if money has been transferred with the consent or authority of the client still has the right to challenge the precise amount through the medium of section 70, subject to the time limits laid down in the statutory timetable. That right exists whether or not the client has agreed the precise amount, whether before or after transfer. And so what the court is referring to there is the fact that the payment in and of itself may be a procedural issue, but it doesn't affect the client's substantive rights if they're able to get through the procedural hurdle, the time bar, and obtain an assessment under section 70. I'll come back after the lunch and adjournment to my learned friend's point about the specific payments in this case, but I hope that assists at this stage.
Yep, okay, thank you very much. All right, well, we'll come back at 2 o'clock. Thank you very much. It must be very hot in there.
Thanks very much.
Vaseline or mayonnaise.